find the record button. Okay, so this is week 9, is it? Already. VLaw, and Shelley's got a presentation tonight, and
Yep.
take it away when you're ready.
Okay, hello to everybody. My presentation is on digital piracy. I have created a little, I'll share my screen in a minute. First, I just wanted to get a little bit of interaction happening with some questions. Does anybody know, or can anyone hazard a guess as to what was the most pirated TV show in 2014?
Game of Thrones.
Game of Thrones.
Yep. Game of Thrones, 8.1 million downloads in 2014. What about the most pirated TV show of all time?
Jeez. I don't know.
Similar field. It was Game of Thrones, episode 6, season 5. It broke the all-time record for the most downloads in 24 hours with 3.5 million downloads. And one more question, the most downloaded movies in 2014. Anybody have any ideas?
2014. Not the Dallas Buyers Club.
Dallas Buyers Club, interestingly, didn't even make the top 20. Any other guesses?
Last year.
It was The
No,
Wolf of
don't
Wall
know.
Street and Frozen, which they both had around 30 million downloads. So I'm just going to share my screen. I have created just a small little PowerPoint, if I can get it to work. And it is not working. Okay, digital piracy is my topic. I have found a lovely photo which I have given the appropriate reference to and obtained from Creative Commons, so I'm not copywriting any material. I first want to start with my target audience. I will be targeting end users or pirates, people that are actually downloading the material, people that are sitting at home with an internet connection downloading shows. Originally, I was going to focus on also looking at the new legislation in regards to site blocking, but I just decided that the whole area was too vast to do both, so I've chosen to just concentrate on end users and how piracy affects the laws surrounding it and how it affects end users. My focus areas, I have 2 specific focus areas. The first one is the laws surrounding the methods of piracy. So there are basically 4 different things different ways that people can pirate material. The first one is by downloading illegal content, which entails making a copy. So that is under Copyright Act 86, Section 86, subsection 1, making a copy of material. The second one is uploading. That is Section 86C of the Copyright Act, and that is communicating in public. Uploading is classed technically as communicating in public. Communicating is defined in Section 10 as making available online. The third one is peer-to-peer sharing. So that's what P2P is. That's I guess, slang terminology for it. Peer-to-peer sharing is essentially only sharing a sliver of material at a time. So it is an area where it's not 100% certain, and in the recent Dallas Buyers Club case, Justice Perham actually questioned the law, saying it wasn't clear. His reasoning was that sharing only a sliver, the legislation requires it to be on a commercial scale for it to be considered an infringement of copyright, and he questioned whether sharing a sliver at any time would would be classified as being a commercial scale. Also, the legislation refers to requiring approved infringement accompanied by a lot of other likely infringements, and it's just not clear, and the explanatory memorandum doesn't really explain it, and the judicial interpretation of it hasn't quite been tested yet, but Justice Perham did in passing mention that it was unclear. So that's something that I'm going to be looking at in my paper. I also just wanted to touch on the international law. New Zealand has on their Copyright Act, New Zealand has actually got expressly written in their Copyright Act to include file sharing, whereas the Australian Copyright Act doesn't make any mention of file sharing as such. It's more implied. The fourth way that people can pirate films and other content is through streaming. This is an interesting area because there aren't any laws expressly forbidding copying via streaming. You're not actually copying when you're streaming. You're not making a copy. It's not being stored on your system anywhere. So as an end user, you're not really committing copyright. It just seems to be a gaping hole in the legislation there. The legislation covers site blocking, which is something that they've just brought in. That was in July. They brought in the site blocking technology, or that aspect where you can apply to the court to have a site blocked, but it doesn't affect an end user. So effectively, a copyright holder doesn't have an action against somebody who downloads via a streaming service that doesn't store a copy on your computer. That is something I will also be focusing on in my paper. My next area of focus will be action that can be taken against end users. So this comes down to where a copyright owner sees that there has been a large infringement of their material on a commercial scale. They can apply to the court to compel an internet service provider to provide the contact details of an account holder. So there are some issues surrounding that I'm going to address. The first one is privacy. Many people think that by the ISPs providing this details that it's breaching the privacy. That is not the case from what we can see. The Privacy Act does have privacy principles in place, although one of the privacy principles, 6.2, permits disclosure of personal information when it's required by law. That's also confirmed in the Telecommunications Act. The next issue that I'm going to touch on will be identity. There was an interesting case in 2007 regarding identification. It was to do with the Roads RTA of New South Wales and a car park. And essentially what happened is the car park operator tried to get the details of registration plates which had infringed the conditions of entry and find out what their details were so that it could follow up on the infringements. The court basically ruled that the driver, the registered owner, even though the registered owner possibly may not have been the driver that infringed the rule, the registered owner should be aware of who was the infringing party, and so that kind of did away with the issues of identity. In the Dallas Buyers Club, he referred to the same principle. So being the owner of the ISP, of the IP address, if you're the account holder, but you're not downloading the material, the court believes that you should reasonably expect it to know who was the infringing party. The other area I'm going to touch on is the remedies that are available. Common practice for when a copyright holder is successful in obtaining IP addresses, the common account details, the common practice is to send a letter, and it's called speculative invoicing, and it's basically threatening large sums of money to prevent you from being sued. So this is a practice that has been widely used in the US, Canada, the UK. Justice Perham in Dallas Buyers Club decided that he was going to follow some recent, in Canada and the UK, they both decided that they were going to monitor what was sent out, and Justice Perham took the same avenue. So he questioned the legality of it. Let me start that again. There are 4 areas that the Dallas Buyers Club wanted to cover in their letter to IP addresses that had infringed their copyright. The first one was a claim for cost for a single purchase of the film. The second was to cover the uploading activity of each infringer. The third one was for punitive damages, and the fourth one was for a reasonable claim of costs. Justice Perham decided that number 2 and number 3 were untenable, stating they lacked legal substance. So that goes back to the peer-to-peer sharing. He didn't see that uploading and sharing. He couldn't find the connection between the commercial sharing one slither of film, how it could be on a commercial scale. So he didn't see that the legislation allowed him to let them claim for uploading. And the other one was for punitive damages, and he just didn't see that that was appropriate either. So since our Australian case, Florida and Maryland in America have actually, the 2 district courts have actually followed much the same practice, and they've decided that they're going to supervise the copyright owners and their letters and the way that they try to entice money from people. The courts are going to pay closer attention in certain states on how they are obtaining their money. They also mentioned in those cases it was to do with the Manny film, and they were questioning the geodata and how the geolocation software, how accurate that was. So I intend to link my page to whoever is doing geodata so that they can give a more accurate description of what that all entails. So that is the crux of what I intend to focus on in my wiki page. Does anyone have any questions or comments?
No, I just think I'm interested to hear more about the P2P sharing. I just find that one interesting because that's probably the one that I use some of it with that sort of stuff. So, yeah.
They have decided that it was a new amendment that was brought in to tack on to the end of section 115, and it was specifically geared towards peer sharing. When a file is shared over a torrent network, it is effectively a slither at a time. So you're sharing, it's broken up into tiny little pieces, and it's a little piece shared at each time. So while you're downloading, you're probably uploading at the same time tiny slithers, and you're downloading tiny slithers. And the legislation is saying that tiny slithers should be a commercial scale, should be considered a commercial scale, because the explanatory memorandum mentioned that you don't really know how much you're uploading. So that's why I assume that they are assuming that it is on a commercial scale. It refers to likely infringements, and that's what that means, that it is you're downloading, so you're obviously uploading on a commercial scale as well and costing the company even more money, and you should be held liable for that. But Justice Perham disagreed, and he basically has said you cannot show, it's something that you cannot prove. You cannot prove whether somebody uploaded one slither or multiple movies worth of slithers. So it's something that's a little untested, and the courts, as they stand at the moment, are still a little unsure of. Justice Perham actually said in his judgment that he wasn't going to go into it. He could see that the legislation was unclear, but he wasn't going to go into it because he didn't see it necessary. He just denied Dallas Buyers Club from claiming money for the uploading aspect.
It's really interesting. I mean, I know my head's a bit in the statutory interpretation space because I've been marking the papers recently, but there's that it's a really great example of the difference between the purposive and literal interpretations. And, on the one hand, courts could take the purposive approach with a lot of this stuff and say the purpose is to stop people pirating. yeah, the technology is changing all this time, and we're going to just basically interpret things broadly in order to satisfy that need. Problem with the Copyright Act is it's so exacting, and it is so literal in the way it's expressed. And every time they update it, they don't actually really update it properly. They just tack bits onto other bits of it that it almost asks to be read in a literal way, because it says that it's expressed in such a minute way. So it's interesting here that if we had a broader statute that basically said it is illegal to dishonestly deal with copyright material, and that will be defined by common law what dishonestly dealing with, we wouldn't have a problem. I mean, you'd have a problem if you're being sued, but it wouldn't be an interpretive problem. But you were saying, I think, that one of them that they've appended, which one was it? Was it uploading has been appended to commercial showing or something?
That's the peer-to-peer that they're referring to.
Peer-to-peer
commercial scale.
Yeah.
It has to be on a commercial scale, and commercial scale is defined as volume and value.
Yeah.
And that is the interpretation.
Okay. So,
and that is the bulk. That is it. The volume and value of any articles.
I bet that's not defined in any meaningful way, is it?
That's very broad. And I think that was Justice Perham's point, that the legislation, that is broad, volume and value, and then it requires a proved infringement, and then it requires some other likely infringements, a large amount of other likely infringements, and that's where he saw that it was lacking in clarity.
I guess when you think about it quite literally, you can file share and you may actually never share with anyone. You can put something available, but if no one else wants it, or it's so widely shared that everyone is taking the piece from somewhere else, literally speaking, no one may actually take that piece that you shared.
Yeah.
So you can never prove that. But yeah, what they're trying to do is get around that. But what they're doing that in a way that's kind of cumbersome. And, honestly, I would have thought the dishonestly dealing would have been a better way to go, but they haven't gone that way. And I guess that's what the judge is saying. He's saying if you're going to go that way, you've got to do it properly.
Yep. And it's also very interesting about streaming. There's no express or even implied mention that streaming is breaking the law in any way, because you're not copying it and you're not communicating it to the public, and that is the crux of what copyright infringement is. And the other thing that I saw was copying is defined as a type of an article or thing, and if it's just being shown on your screen and then it's gone, then you're not retaining any article or thing, so you're not creating a copy, so you're not infringing any copyright by just streaming TV shows live from these websites.
It's kind of frustrating. On one hand, it's frustrating. On the other hand, it's interesting because it gives us something to talk about. That other areas of law don't face the same level of scrutiny. When you think about the laws of conversion and theft, they require an intent, and they require dealing with property that's inconsistent with the rights of the original owner, I think, for conversion, if I'm remembering that correctly. And that's to cover the fact that you can just sort of joyride or steal something and hand it back, and that's still considered conversion. So the common law approach has been kind of like, yeah, we'll set the parameters and we'll work within that. Whereas here, we're not doing that at all. We're setting these incredibly arbitrary kind of distinctions that a lot of our common law rules, and in fact our statutes, wouldn't be able to face the same type of scrutiny. So it's interesting why the area of copyright is so fractious. I think part of it. No, go ahead.
Sorry, go.
I was just saying, I think part of it might be the problem is it's treated like theft, but it's not. If you actually was a physical product people were stealing, we wouldn't have this problem. The problem with copyright is you're making a copy of something that doesn't deprive the original owner of the thing that they have. So therefore, we've got to be really careful about how we use those laws. I'm thinking maybe that's the reason, but open to other opinions.
And it's like the legislation was created by someone that's not familiar. The explanatory memorandum with regard to peer-to-peer sharing, it says that it is targeted at electronic infringement, i.e. peer-to-peer sharing. It expressly mentions it. But then the legislation says proved infringement and a likely infringement, and it basically, because it doesn't mention anything else, it's referring to the infringement being taking of a whole movie, and you just can't prove that through any kind of the way that they will grab IP addresses, a section of IP addresses. It's just not provable.
However,
so that's why that's why Justice Perham is almost questioning the legality of the legislation.
it often happens actually that often when, particularly on appeal, seems to happen even more, that judges are more taking exception to bad drafting than they are at the actual law themselves. So as soon as you annoy them by drafting something poorly, you're in for it, regardless of what the consequences are. And I suppose fair enough. I haven't looked at the New Zealand legislation, but it would be relatively easy just to say it is illegal to file share in a way that infringes the copyright. It would be a bit more complex than that. But as you said, if they made express reference to it, they wouldn't have this problem.
Yeah, New Zealand legislation is very, very clear. It says that basically that it includes file sharing. This covers file sharing, and it also includes a 3 strikes policy before they will allow a content provider to take your account details from an ISP, which is actually in the process of being implemented here. It was supposed to be, they were talking about it being implemented in September, which it is now September. But I haven't had a close look at that yet to see whether it will actually have any effect at all on the federal court application of preliminary discovery, whether they have to wait for the 3 strikes before they're allowed to, or if they can still do it anytime they want. I haven't actually clarified that.
Yeah, because it may be in terms of the date of the enactment will have passed. The wrongdoing will have occurred before the amendment was enacted, so that might not cover it. But
it's not an amendment. It's an industry code that is being brought in by the Australian Communications Media ACMA Association. Is that the last letter?
Yeah, I believe so. Used to be authority, I think, when it was the ABA. Okay, so it's an industry code, co-regulation code, which is, again, it's like one of those things that, like international law, it's one of those things that you learn a certain way of thinking about law, then you hit these other areas of law that don't quite work the same way. And it's a real challenge if you do something like human rights law, because there's all this stuff that looks like legislation. You go, okay, I know how to deal with this. I've done law for 4 years or 3 years, I know what it is. And suddenly you realise, oh, hang on, it's international and it's not enforceable. And is it still a law? Isn't it a law? And we went heavily into around 2000 onwards into industry co-regulatory schemes for multiple motives. On the one hand, it was government passing the buck and just saying industry deal with it. But on the other hand, it was also, I think, a sensible way to try and get the people who were going to be regulated involved in the regulation. But in the internet world, they did that fairly poorly by picking the wrong people to be in the association.
The industry code that they're looking at implementing, I had a look at it, and it doesn't include any reference to peer-to-peer sharing or streaming either. So they're covering uploading and downloading, and I think the idea of it is to create a bit of an education system and frighten some people. You get a letter in the mail from your ISP, you might lose your internet, you might get in trouble, but it's not actually dealing with, the gaping holes in the legislation.
Yeah. There's a whole field here that's interesting in terms of deterrence and what deters people and what actually, how you govern people's behaviour. And, you know, you probably don't get a chance to look very much at criminology, but criminology is a really interesting field where they've spent a lot of time studying what it is that deters people. And there's a concept called threshold deterrence that basically says a lot of the stats we've got on deterrence show that no matter how harsh a deterrent is, it doesn't affect behaviour. But there's a threshold of deterrence. If something is illegal, that is a significant, and there is some kind of, you know, certainty in, vague certainty in being detected and caught and cautioned or whatever. There's a threshold of deterrence that deters most people. It's just that going from a fine to the death penalty doesn't have as much of an increase in effect as you'd think it would. In fact, death penalty actually seems to work the opposite way. It seems to actually be a non-deterrent, less of a... So people spend their lives studying this stuff, but I don't think it's very often applied to something like piracy.
Well, talking about the site blocking legislation that I've chosen not to go into,
Yeah.
In 2012, the Netherlands banned Pirate Bay from the Netherlands, banned the Dutch from accessing Pirate Bay. They found that it had no effect at all on 94 to 96% of the Dutch. So in 2014, they lifted the ban, and now they all have access to Pirate Bay again.
So it's going to be interesting to see whether the threat of being sued within an inch of your life is effective, and on the other hand, whether just getting a letter from someone that says, actually, you think you're doing this and no one's noticing, but we're actually noticing, whether that has an effect. And it'll have effects on different people, I'm sure. The other thing I think that's an interesting, and it's not directly legal, although law enables it, is the rise of things like Netflix. There's been a lot of discussion about the way that Australians are very heavily into piracy. But that's also because Australians have had a very restricted access to media. And, you know, in the past you had to wait for the commercial channels to get it a year after it played, and then they wouldn't play it, all the series and all those sorts of things. So there's a whole lot of just excuses people have and reasons why we have a sort of a piracy-friendly culture. Well, now we've got Stan and Netflix and everything else. Is that going to actually affect rates of privacy?
Yeah.
Piracy. Different thing.
There has been a major downturn in piracy since Netflix and Stan in recent times. They have noticed a great downturn. But the shows that are getting downloaded lots, for example, Game of Thrones, are ones that aren't available readily. They're only available through one avenue. So Game of Thrones is only available through Foxtel.
Yeah.
If you want it immediately. If you want to watch it a little bit later, you can get it through Apple TV, but it's only available through Foxtel. So if you don't have it, you don't get the show. I thought it was actually interesting because Foxtel were set to be the first ones to do the site blocking, to attempt to get sites blocked for piracy reasons. And then there was no further mention of it. And then I looked up today when the new Game of Thrones season airs, and it's in April. So now I'm wondering if they are looking at postponing for a little while. Maybe somebody else will test it in the meantime, and then they will lodge their application to block these sites closer to when Game of Thrones is going to be released, so that they can actually, their legislation or the blocking of the sites can actually have some effect on their revenue. People can't access the site, so they ring up, they get Foxtel put on, and it increased Foxtel revenue. That's all I can think of.
Or, as I think Brendan suggested, they get frustrated and learn how to use a VPN to get around the site blocking. In which case...
Yeah, I've stayed away from that in my topic.
At least they're learning something. They're learning something about how to use computers and networks. So it has some positive outcome.
My search history, having searched for all this and looked at different streaming sites, and my search history will be something for people to marvel at, I suspect, over the last few days.
Yeah, well, I did a PhD in censorship of adult content, so, you know. I'm sure my 2000 to 2005 site history was fantastic as well. Although not as great as the office of one Tasmanian senator who was a very strong moral anti-pornography campaigner, and then someone leaked his internet history and showed that he had to do a lot of research into that pornography that he didn't like to prove it to himself that he didn't like it over and over and over again. Embarrassing when that happened. So yeah, interesting topic. And as you said, like particularly at this stage, because you guys are getting the first run at this, you can't cover everything. But I think the area that you've selected is really good. I'll give you more feedback as we go, and on your draft that you hand in and everything else. Really interesting. I made some notes here to think about. But yeah, well done. Very interesting.
I was also hoping to, I'm not sure how the word count works, but I was also hoping to just, because it is such a relevant case on piracy and a lot of other issues, I saw geodata and privacy. I was hoping to just do a small kind of case note on Dallas Buyers Club to include in the wiki.
Yeah, and that'd be really good. And again, because it's a wiki, even if it's brief, and if people want to add more to it, they can add more to it. So that's one of the advantages. In terms of word count, the main reason the word count, I mean, obviously, if you go too crazy, I'm not going to be able to read it all. But the main reason the word count is there is to stop you spending more time on this to the detriment of your other studies. So I'm not going to be, thank you, Raz. I'm not going to be incredibly strict about it, but it's more to say, if you did get really excited and wanted to write a 20,000 word thesis on it, which some people occasionally do, to say, don't do that because you're going to fail everything else if you're focusing so much on it. So that's how the word count works, yeah. Okay. Well, we've only got one on tonight. Has anyone got any other comments or things to say? Otherwise, we might be able to finish up a bit early tonight. We might be a bit late. I think we've got 3 next week, so we might go a bit later next week. And we'll see how it all goes. Okay, I've been suitably educated, and I'll upload this tomorrow.
Great. Okay, thanks, Scott.
Okay.
Thank you, and thanks, Shelley. You did great.
Thank you.
See you guys.